Today, I'm going to discuss how immunity doctrines notified the social contract and why we owe the state nothing. They told us we had a deal. From the moment we were old enough to understand the word citizenship, we were taught that we live under a social contract. The state protects us, we obey laws. It's supposed to be a fair exchange between the governed and those who govern. But I want to ask today something simple, something that law schools spend years teaching students not to ask. What kind of contract only runs one way? Because here's the truth that they don't take textbooks. You have obligations to the state, absolute duties. You must pay your taxes or go to prison. You must register for selective service. You must obey every law on the books, federal, state, and local, or face prosecution. You must comply with officers who stop you, courts that summon you, and governments that constrict you. The state, however, owes nothing beyond what it chooses to owe. This is not a social contract. This is a system of enslavement, one where the master calls the instrument of your enslavement a constitution. Let's begin with what we were promised. The Constitution of the United States is on paper one of the most radical documents ever written. It tells the government what it cannot do to its citizens. The First Amendment says Congress shall make no law abridging your freedom of speech. The Fourth Amendment says the government cannot search your home without a warrant. The Fifth Amendment says the state cannot take your life, liberty, or property without due process. The Eighth Amendment prohibits cruel and unusual punishment. These are not suggestions. These are prohibitions, hard limits on state power written in plain language, ratified by the people. Then in 1871, Congress went further. Still scarred by the atrocities of slavery and the Civil War, lawmakers passed 42 U.S.C. 1983. The law is direct. It says every person who acting under a citizen of their constitutional rights shall be liable to that person. Every person shall be liable, no exceptions, no carve-outs for badges or roles or government offices. The word every appears for a reason. Congress meant it. So we have a constitution that limits state power. We have a statute that holds every state actor liable for violating that power. We have courts sworn to uphold both. So where could we go wrong? Here's what went wrong. The courts rewrote the social contract. It wasn't Congress, it wasn't the American people. There was no constitutional amendment that was ratified through the democratic process. The courts, unelected judges, accountable to no voter, invented an entirely parallel system of protections for the state and its agents. Protections that appear nowhere in the Constitution, protections that contradict the plain text of the statutes Congress passed, protections that ensure no matter what a government official does to you, you will almost certainly never see a day in court. This system is called immunity. And they built it piece by piece, case by case, decade by decade, until the wall between citizen and accountability became so high that the Constitution behind it functionally became irrelevant. The doctrine says a police officer, a prison guard, or other state official cannot be held liable for violating their constitutional rights unless that they violated a right that was clearly established at the time of the violation. To show a right is clearly established, you must point to a prior court decision with nearly identical facts where a court ruled that the specific conduct was unconstitutional. In other words, to sue an officer for violating your rights, you need a prior case finding that right was violated. But to get that prior case, someone had to successfully sue an officer, but they needed a prior case to do so, and so on, going back forever. If officers find a creative new way to violate your rights, a way that hasn't been adjudicated before, in a sufficiently identical factual circumstance, they receive immunity. The right may exist in the Constitution. Everyone in a room may know it was violated, but no court has ruled on this specific configuration of abuse before, which means the officer walks away. This is not a legal doctrine, it is a logical trap specifically engineered to make accountability impossible. And the numbers prove it. Between 2006 and 2024, police officers in the United States paid just 0.2% of the dollars awarded in settlements and judgments for misconduct. The remaining 99.98 was paid by taxpayers. Officers face no personal financial consequences whatsoever for violating the constitutional rights of citizens. Justice Sotomayor wrote in her dissent in Kaesler versus Hughes, qualified immunity sends an alarming signal to law enforcement officers. Tells officers they can shoot first. She was correct. The doctrine gives state officers a license to harm you with near certainty that no court will ever hold them to account. And here's the most important fact I can tell you about qualified immunity. The Constitution does not mention it, not once, not in a single amendment, not in any clause. Congress did not create it. The Supreme Court invented it from nothing, built it through decades of rulings, and used it to erase every statute, Section 1983, that Congress passed specifically to hold state actors accountable. The court rewrote the law that Congress wrote and dared anyone to challenge them for doing so. But qualified immunity is near absolute protection. Prosecutors receive something worse, absolute immunity. If a prosecutor fabricates evidence against you, they cannot be sued. If they withhold proof of your innocence, evidence that could have freed you in 20 minutes, they cannot be sued. If they knowingly put a lying witness on a stand, suborn perjury, or charge you with a crime they know did not exist, they cannot be sued. Even if you spend 30 years in a cage before DNA evidence finally exonerates you, even if the prosecutor knew you were innocent from day one, even if the misconduct was deliberate, malicious, and thoroughly documented, the prosecutor goes home, they keep their pensions, they face no consequences. The Supreme Court invented this immunity, again from no constitutional text, reasoning that prosecutors need protection from disgruntled defendants. Think about that reasoning for a minute. Every other professional who holds power over human lives, doctors, lawyers, architects, operates under the threat of liability for malpractice. That threat is not incidental. It is a mechanism that creates accountability and incentivizes competent ethical conduct. Prosecutors alone are exempt, and the results are exactly what you would predict. Studies document rampant Brady violations, prosecutors withholding exculpatory evidence, knowingly false testimony, improper conduct before juries, vindictive charging decisions. This conduct persists because the people challenging it bear no personal risk. The people engaging in it bear no personal risk. Absolute immunity does not fall to deter. It doesn't just fail to deter misconduct, it actually rewards it. When misconduct is free, you get more of it. This is not a controversial proposition. Now we arrive at the most philosophical, obscene doctrine of three: sovereign immunity. The principle is ancient, borrowed from English monarchy. The king can do no wrong. You cannot sue the crown without the crown's consent. The American founders, who had just fought a revolution against the king, explicitly rejected this principle. In Federalist Paper 81, Alexander Hamilton wrote that under the new Constitution, states would be subject to suit. The whole point of establishing a republic was to replace the royal prerogative with the rule of law. The 11th Amendment passed after the founding with a narrow vote. Read what the 11th Amendment says. It bars federal suits from hearing suits against states brought by citizens of other states or foreign nations. It says nothing at all about a citizen suing their own state for violating their rights. Courts read it anyway as establishing broad sovereign immunity, stretching a narrow procedural provision into a sweeping shield against accountability. In Hans versus Louisiana, the Supreme Court held that Louisiana possessed immunity against suits even by its own citizens, a conclusion that directly contradicts the amendment's text and the founding generation's explicit intentions. The result is this: the state can violate your constitutional rights, you can prove it, you can document it, you can walk into federal court with irrefutable evidence, and the state can respond with two words: sovereign immunity, and the case is dismissed. You have no remedy, you have no recourse. You have no ability to compel the state to stop violating your rights, to pay restitution, or to face any consequence whatsoever. You cannot sue the state for harming you without the state's permission. Let that principle sit with you for a moment. You cannot obtain justice from an entity that violates your rights unless the entity consents to let you seek justice. No rational person would ever consent to being sued. The doctrine exists for the precise purpose of allowing states to violate rights without consequences. This transformed constitutional rights from enforceable guarantees into polite requests. The Bill of Rights becomes a wish list, the Constitution becomes theater. And finally, who built this system? The judges. Judges wrote the opinions inventing qualified immunity. Judges authored the decisions expanding prosecutorial immunity. Judges strapped the 11th Amendment into sovereign immunity doctrine. Unelected judges wielding lifetime appointments systematically dismantled the accountability mechanisms that Congress and the Constitution created. And then, naturally, inevitably, those same judges granted themselves the most complete immunity of all. Absolute judicial immunity shields judges from civil liability for any act performed in their judicial capacity. Any act, no matter how corrupt, no matter how biased, no matter how clearly it violates established law. A judge who takes a bribe cannot be sued. A judge who conspired with a prosecutor to convict an innocent person cannot be sued. A judge who deliberately ignores controlling precedent to harm a litigant cannot be sued. The people who built the wall protecting the state from accountability make sure to stand safely behind it first. Now let's return to the social contract, or rather its corpse. The doctrine is not merely flawed, it is not in need of reform. It has been nullified entirely. The arrangement describes in civic classrooms mutual obligation, reciprocal duty. A government bound by the same law it imposes does not exist. What has been constructed in its place is something categorically different: a unilateral system of obligation flowing exclusively from citizens to the state, enforced by violence, and shielded from challenge by courts that serve the power they purport to check. Under any coherent theory of contract, any version taught in any law school in this country, a valid contract requires mutual obligation. Both parties must owe duties. Both parties must be bound. A contract where only one party bears obligation and only one party can be held to account is not a contract. It is coercion wearing a contract's clothes. So what do citizens owe the state? Everything. Taxes, compliance, military service when summoned, obedience to thousands of laws at every level. Violation of any of these obligations carries consequences, fines, imprisonment. The full machinery of its citizens. Whatever it decides to owe them, it may waive sovereign immunity for some causes of actions or not. Officers may be held liable when they violate, but the courts ensure almost nothing is clearly established. They face accountability when they act outside judicial prosecutorial function, but broadly that misconduct always falls within it. This arrangement is unilateral. That word must be used plainly and without apology. You are bound, the state is not. You have obligations, the state has discretion. The social contract has been nullified, and with it, so have the moral obligations that the state claims to derive from it. This means something important, and it should be said without flinching. You owe the state no moral duty beyond what it has the power to force you to do through violence. No allegiance, no loyalty, no deference beyond the raw coercion it compels. The state has not held up its end. It never intended to. You did not consent to this arrangement. You were born into it before you could speak or reason or agree to anything. And the mechanism that was supposed to make the arrangement legitimate, the ability to hold the state accountable in court, has been systematically dismantled by the state's own employees. Do not feel guilty about this. Guilt requires a real obligation violated. There is no real obligation here, only the threat of force dressed in the language of civic duty. The laws of the state are not legitimate because they reflect justice or mutual agreement. They are legitimate only in one sense. They are backed by violence. The state can imprison you, seize your property, and kill you if you resist with sufficient force. That is not the entire basis. That is the basis of your obligation to obey, not morality, not consent, not the social contract. Violence and a credible threat thereof. You can acknowledge this honestly without becoming a call to recklessness, without it becoming a call to recklessness. It is simple clarity. The state wants you to believe your compliance is an expression of civic virtue, of shared obligation. It is not. It is the rational response of a person who understands where the power lies. That is all. There's a question at the heart of all of this, and it deserves to be asked plainly. What more? If you ask most Americans, courts exist to protect your rights, to provide a neutral forum where citizens can seek redress for wrongs done to them, to hold the powerful accountable, to ensure that the Constitution means what it says. But examine what courts actually do when citizens come before them with constitutional violations by the state. They ask, do you have standing? They ask, is the right clearly established? They invoke sovereign immunity. They grant summary judgment. They issue unpublished opinions so they don't have to create new precedent. They dismiss on mootness. They dismiss on ripeness. They dismiss on political question doctrine. They deploy a vast arsenal of procedural weapons, none of which appear in the Constitution, all of which point in the same direction. Your case will not be heard. Courts are institutions of state power. They were created by the state, funded by the state, and staffed by officials who owe their positions to the state. Asking courts to hold the state accountable is like asking slaveholders to abolish slavery. No institution will declare itself illegitimate. No powerful structure will voluntarily dismantle itself. When a judge invokes immunity to dismiss your case, they are not applying the law. They are protecting the system that appointed them in the first place. They are telling you, in the formal language of legal doctrine, that your rights are real only when the state chooses to honor them, and the state rarely chooses to do so. A constitution with unenforceable rights is not a constitution. It is a promise made by someone who has no intention of keeping it. It is a social contract drafted by one party, signed by the other under duress, and interpreted by the first party's employees whenever a dispute arises. None of this is hidden. The cases are public. The statistics are available. The constitutional text that contains the word immunity, the constitutional text that does not contain the word immunity is readable by anyone. What is required simply is the simple willingness to look at what the system does rather than what it claims to do, to judge it by its outputs rather than its rhetoric. When you do that, this is what you see. The law imposes duties on citizens. Citizens who violate those duties are prosecuted and imprisoned on the state. In theory, state actors by qualified immunity, absolute immunity. sovereign immunity, and prosecutorial immunity, and a procedural gauntlet specifically designed to ensure that theoretical duties never become actual accountability. On one side of this arrangement is enforceability. On the other side, there is no enforceability. The obligation is unilateral, and the side that is not enforceable is the side that holds all the power. That is not a social. There is no mutual obligation between equals, but a unilateral system of obligation flowing from the citizen to the state and violence legitimized by elections that often adjudicated by courts that are themselves instruments of the power they purport to check. The founding fathers gave us a constitution to prevent exactly this. Congress gave us Section 1983 to make it real. Courts have spent a century and a half dismantling both, not through the democratic process, not through Constitution Amendment, through the quiet accumulation of invented doctrines that protect Satan remedy. Immunity is not in the Constitution, as absolute prosecutorial immunity is not in the Constitution. Sovereign immunity, as applied to citizens suing their own states, is not in the Constitution. Absolute judicial immunity is not in the Constitution. They were placed there by the people who benefit from them. So I return to the original question. What kind of contract only runs one way? This is not a contract. This is a fiction. A useful fiction for those in power, a harmful one for everyone else. The question before us is not whether the system has flaws that can be reformed around the edges. The question is whether a system built on unenforceable promises, compelled consent, judicially manufactured immunity for the powerful, and a unilateral obligation can call itself a constitutional democracy with any honesty at all. Rights that cannot be enforced in court are not rights. They are suggestions. They are privileges. A constitution that cannot be enforced against the state is not a constitution. A social contract that binds only one party is not a contract. It is a euphemism for domination. And a moral obligation that rests on nothing but the threat of force is not an obligation at all. It is a demand. You are entitled to see it that way. You are entitled to stop carrying guilt for a compact that was never honored on the other side. The state's laws command your compliance because the state will harm you if you refuse. Not owe anything more than that. Strip away the civics class mythology, and what remains is exactly that: threat and a rational calculation of a person who stands both. Until immunity doctrines are abolished, they invented to that were invented circumvent these demands. The promise written in a document will remain exactly that, a promise, written in beautiful language, honored by no one with the power to honor it. The court built these doctrines, and it will not be the courts to tear these doctrines down. That work belongs to the people who were supposed to be protected in the first place.